Welcome to Canada's Social Changemakers. My name is Justin Douglas, and today I am here with two not only social changemakers, but game changers, Val Napoleon and Jessica Asch of the Indigenous Law Research Unit in Victoria, British Columbia. Val Napoleon is the co-founder of the Indigenous Law Research Unit and of the Joint Degree Program in Canadian Common Law and in Indigenous Legal Orders. She's also the Law Foundation's Professor of Indigenous Justice and Governance at the University of Victoria. Jessica Asch is the Research Director for the Indigenous Law Research Unit. She's also in charge of leading the collaborative research and public legal education process on Indigenous law. She is a self-identified settler from Treaty 6 territory, and she's also on her way to working for an LLM graduate student at the University of Victoria. Thank you both for being here today. So just before we start, I'd like to acknowledge that we are on the unceded territories of the Lekwungen-speaking peoples, the Wisanish peoples, and of the Esquimalt and Songhees nations. So let's get started. Okay. Val, how did you get involved in law? What was your process? Where are you from? And how did this journey start for you?
So, I have two stories about how I got into law.
Mm-hmm.
I started law school when I became a grandmother, and so the first story is that when my daughter became pregnant, I sat around thinking about the wise things that I would tell a little grandchild. And so I'm thinking about the wise things, and one of the things I wanted to say was, listen kid, if you want to do something, you gotta go and do it. Right, not so profound, but I wanted to be able to say that. And then I thought to myself, well, I actually haven't done that, have I? Because when I was in my early 20s, I applied to go to law school and didn't go. Life happened and I didn't go. And so I thought, well, I better go and do it. So
Wow.
that's the first story.
Okay, keep going.
The second story is that pretty well all my life prior to moving to Victoria, I lived in the north of BC, and I did work that I loved. I worked with Indigenous peoples, communities on all manner of things, justice projects, economic projects, everything. And as I was aging, I realized that Indigenous women disappeared. They became part of the backdrop, but they weren't directly involved with doing the kind of work that I love doing. And so I figured I needed a new driver's license for this world where I was aging, where I could keep doing the kind of work that I love to do. So that was my step into law school.
So interesting. We're going to dive into that a little bit more, but first I'd like to welcome Jess also to our little interview today. Jess, what was your experience and how did you get involved in the legal world and into eventually Indigenous law?
Thanks, Justin. I have a really unique experience as a child of immigrants from the United States, and my parents lived in the Northwest Territories, and were actively engaged in political struggles of the Dene Nation when I was a small child. And my father was heavily involved in questions of law and colonial law, state law, involving Indigenous people. So I had a different narrative about what law was from a very young age. So there was always something from the beginning that made me curious about the place of state law in this world, in the erasure of Indigenous territory, Indigenous people, Indigenous laws, when it was so evident to me that it was alive, that people were telling the stories, that people were actively engaging with stories about their own land. But it was later in a personal journey of mine that I started getting interested in state law, which was my partner is from Guatemala, and I had gone to Guatemala after dropping out of first-year university, thinking I knew the world and could help on my own with no skills whatsoever. So I went to Guatemala, and I started working in a community with very little Spanish, very little skills, and in fact the community I was in was a predominantly Indigenous speaking community. So I actually had no way of communicating, not even in people's second language when I was there. And I had this insight about how here I was, a young 22-year-old settler kid from Canada, going to another country to figure out how I could help other people in another land, and how horribly I was doing that because I had no skills to do it. So I had an eye in my mind about, okay, well, what are the tools that I need to advance questions of justice, to advance questions of solidarity, and then why am I here in Guatemala doing this work when there's so much work to be done as a settler person in Canada. So I applied to law school from Guatemala, and came back to Canada and started the journey that way. And then when I was in law school, I was astonished to see this continuing. I should say I wasn't that astonished, but it constantly surprised me that there was this continued erasure of Indigenous people's experiences, Indigenous people's law, Indigenous people's language and histories in my classes. So it wasn't entirely the experience that I wanted it to be. And so when I went out into the legal world, and I worked as a lawyer in privacy law and in labor law, I was trying to, in my own way, without the language for it, incorporate aspects of Indigenous law into my work, and it was falling on deaf ears. So it wasn't until a very lucky encounter with Hadley Friedland, who is co-founder of the Indigenous Law Research Unit, who is co-founder of the methodology that we use. I ran into her in a farmer's market in Salt Spring Island, and I had just, left a job because it was feeling unsatisfying to me to be engaging in this. And she had just finished up the very first project, the inaugural project that the Indigenous Law Research Unit was doing with Val, which was the Accessing Justice and Reconciliation project.
In Canada, we have sort of three legal traditions that are commonly considered. The common law approach, which is based on British English law and a set of precedent. The Quebec Civil Code, which is based on this book, where we look to see what the rules are codified in a sense. And then there's Indigenous legal traditions, which are often based on oral histories. And so two of the legal systems have often been undermined by the largest legal tradition, which is common law. And at McGill, I was able to do the double major in common law and civil law, but I always felt like there was a third tradition that was not being talked about or discussed enough. And that was one of the criticisms I had while I was there, is that I felt that there should be more inclusion of Indigenous perspectives, because McGill Law offers what they call a trans-systemic learning system, which is the idea that all legal traditions are equal and valid, not better or worse than another ones, just looking at them through different lenses, and not comparatively, but they all exist together and they can coexist. And the University of Ottawa offers a similar program where you do 3 years in common law and 1 year in civil law, but there has not really been an Indigenous law program until now. So what is the new law program, and how were you able to implement it in Canada?
So, this is so interesting. So it's really helpful to think about Canada as multi-juridical, that every geographical space is filled with different legal orders. There's more than one legal order in every geographical space. And it's helpful to think about Indigenous law on a societal basis. So there's or a large alliance basis. So there's a Cree legal order, there's a Dene, there's Saulteau, there's Gitksan, and so on across Canada. So there's that. One of the idea for the Indigenous Law degree program, which is over 4 years, and the first year of courses and some of the upper year courses are basically double courses. So they're taught trans-systemically with common law and an Indigenous legal order. So I teach Gitksan, land and property, and common law, land and property. So each of the courses is taught with an Indigenous legal tradition. So the idea for that came from, originally from my colleague John Burroughs, who was musing about the McGill program and saying, why can't we do that for Indigenous law? And so that was, way back when, 15 years ago, the kernel. And then, the conversations have continued. And the early conversations were really hard because people didn't recognize there was any Indigenous law. And there would be denial that there was such a thing. So part of why the work of the Indigenous Law Research Unit is so critical to changing the discussions, the conversations, is because we, through those reports that Jess has described and through other materials, our graphic narratives, our videos, teaching guides, all the different things that we create, which are plain language and accessible, and they're out there. And they're complex, they're not simple, they're not philosophy, they're law from different legal orders. What those materials and the work we've been doing has done is show people that you can work with Indigenous law. It's not this intellectual black hole, like that's impossible to ever understand unless you're Indigenous. It's law. You can work with it, you can access it, you can reason with it, you can do all these different this work of law with it. So so the Indigenous law I think did lots of the work to establish the foundation of possibility, to begin expanding the legal imagination in Canada, along with a gazillion conversations that we've had, John and Jess and Hadley and others about Indigenous law. And all of that has enabled us to get support for an Indigenous law degree program. And we're now in our third year. We have our third cohort coming in COVID times.
Yeah, we'll talk about that too, how COVID has affected everything, but that's later.
Yeah. So it's, as I mentioned, it's a 4-year program, and that's because of the doubling up of the courses, but it's also because in the 3rd and 4th years there's a field school. Now, the field school this coming January is coordinated with Cowichan tribes and with the Stalo. We're not quite sure how it's all going to work virtually, but it is going to work.
It's a changing world.
It's a changing world. It's astonishing what can be done. So that's so it's in process, and we're learning as we teach, as we develop the curricula, as we figure stuff out. I have learned so much from figuring out how do the subject areas of Gitksan land and property correspond with common law property. It's not a comparative. You don't just hold it up and say, look, these categories are the same, because systems of law are shaped by the society from which they come and from the economic order through which people structure their society. So the purposes of Gitksan intellectual property, for instance, yes, there's intellectual property, but it's actually the governance system. Mm-hmm. And it fulfills a different purpose there than the intellectual property within common law. So there are many lessons like that are just such an opportunity to learn along with students. And we've made, there've been ups and downs.
Imagine.
We have lots more to learn.
You also have this thing called ILRU, which is the Indigenous Law Research Unit. Mm-hmm. What is that, and how does it fit into everything else that's going on?
Do you want to start that?
Sure. So we're a research unit dedicated to the revitalization and standing up renaissance of Indigenous legal traditions. So our work is entirely community-led, community-directed work, but we work in collaboration. is about building partnerships with Indigenous communities who are seeking to restate or articulate or stand up their laws for their own governance purposes, for teaching, for working across legal traditions, whether it's with other Indigenous legal traditions or state law. So the work that we do is we apply what we have learned, the tools that we have within the common law system and other methodologies to engage with Indigenous legal resources. And by Indigenous legal resources, I'm talking about oral histories, I'm talking about Indigenous language, sometimes it's embedded learning within community, interviews, focus groups with people. And we do what lawyers trained in the common law do very well, which is we organize and we synthesize the materials that we engage with, that we work with, and we to lay out principles and processes that exist, that we see within the Indigenous legal tradition. So the main work that we do in partnership with Indigenous communities is to build reports around a specific question of law, so whether it's citizenship law or human rights law or water law, that outlines who might be the major decision makers regarding that legal question or that legal area of law. What are the procedural steps to come to a solution? What are the responses within this legal tradition? What are some of the obligations? What are some of the rights that emerge from this legal tradition? And we package this up and we engage with community to talk about what we've learned, and together collaboratively we work with our findings to create a collaborative, a final product, which is a report that's given back to community. That's just one aspect of our work. These are cycles of about 2 to 3 years of embedded, really intellectually challenging but inspiring work. It's the best work on the planet, I have to say. And we have enormous creative staff engaging with this work. These reports that we create in partnership with community, we then use to talk about, teach, engage with Indigenous law with the broader community. So whether that's in the broader public, we've done speaking events all across different sectors, private sector, public sector, at the art gallery.
That's the beauty of filming in an outdoor environment. There will be some outdoor background sounds. Ignore them. Focus on Jess.
But we have a public legal education mandate, essentially, which is to lift up Indigenous law. We want to make Indigenous law take up just as much space as Canadian law does today, as state law does today. So whether that's speaking in a classroom or engaging with social workers or creating toolkits and videos for people to start engaging with Indigenous law, that's the other half of the work that we do. So it's really a unique process of really deep, intellectually engaging engagement with Indigenous law, and then creating resources to enable people to access and understand the Indigenous law better.
Those resources too are amazing, I have to say, because for someone who wouldn't necessarily have access to Dene family law or Gitksan public law, I mean, there's all of these different facets that I, as a colonial Canadian, settler Canadian, would never have access to otherwise. And this is really bringing information not only to the communities themselves, to the law school, but really to the general public in a way that's never been done before in Canada. And it's creating a whole archive of information that is pretty amazing to have in the public discourse for the first time. But the research and the information that you do can also inform the law students within the program, as well as the Canadian governments and provincial governments, territorial governments.
And the judiciary.
And the judiciary, exactly, in the way that we move forward within the legal framework, and in the way that Indigenous law is brought into the way that the landscape of the greater Canadian legal systems. And that's sort of where I want to talk about next, is how do you feel we are doing so far in incorporating Indigenous law into the greater juridical conversation of the Canadian landscape?
We're in the early stages. I mean, I think one of the things that you've been able to see from looking at the research unit and our work is that there is no intact Indigenous legal order anywhere on the planet. They've all been undermined and distorted by colonization and continuing capitalism, imperialism, and so on. So the work is fundamentally about that rebuilding, which is about rebuilding citizenries, right? It's about rebuilding peoples, because law is essential to people being people, to a society being a society. So, so there's the work of law extends in, and what Jess said is really important. There is no quick fix. Each initiative, each research project is, a minimum of a year and a half, but it usually extends for years, because what people are doing in engaging with this work is reclaiming the language of law, reclaiming their own intellectual resources as part of a reasoning framework to solve problems, and reclaiming the grammar of law so that people can have conversations about it and reason together. Like, that's the first step to citizenry. It's the first step to solving problems, and that it's essential for issues, those larger, haunting, horrible issues like the murdered and missing Indigenous women and girls. Like,
Yeah.
Those, one of the things that I've said, and you've heard me say before, is that where Indigenous law has been undermined, where there are gaps in Indigenous law or distortions of Indigenous law, and where Canadian law has failed, those factors create spaces of lawlessness within which violence happens. And to rebuild safety, inclusion, fairness, all of the kinds of aspirations that we have for law, whether we live up to them or not is another thing. But to be a people, you have to be able to imagine yourselves better than you are at any moment. And that's part of what the work enables.
Yeah, and it's also interesting too that it's a very complicated history in Canada when we're talking about Indigenous and settler relations. And one of the things that stuck out with me in my education was the juxtaposition of treaty relations in the way that historical Canadians have been able to interact with Indigenous people, but then also this thing called the Indian Act. So on the one hand, with a treaty, it's almost as if there were two equal founding peoples in equal relations, and then at the same time, this Indian Act comes in, and Canada basically says, no, you're not just equal, you're also a subject of the Crown. And through that legislation was basically a tool for colonization, for the erasure of culture. And so where are we now in terms of this in Canada, and how can we improve?
So the difference in Canadian history from one coast to another and to another. So there's like 400 years difference.
Mm-hmm.
So, Frank Calder, who was the plaintiff, the main plaintiff in the Calder decision, remembered when he first saw the first white man coming to the Nass Valley. Okay, that's how recent the history is in British Columbia. So there are big differences in terms of political and legal reorientation of, according to Canadian legal benchmarks and according to things like the Indian Act. The Indian Act is still the default and related legislation with it form part of that default in Canada, unless people create other ways, other political and legal arrangements with the state. So either through what are called modern day treaties, or government to government agreements, or any number of other ways that people choose to relate to Canada. The fallback is the Indian Act. It hasn't gone anywhere, which is always interesting. It has been the source of ongoing conflicts for many, many peoples because of that. Part of what the Indian Act and the Canadian legal system have done is taken horizontal non-state legal orders and political ordering and made it vertical through chiefs of council and through different relating to through Canadian legislation to the state. So what that means is that the horizontal accountability processes have been broken down, have been undermined. And so when we talk about rebuilding law, part of it is about those horizontal systems of accountability between peoples, and we have a party of crows now.
Yeah, they're saying hi. They're giving us our blessing, hopefully.
And visibilizing those horizontal relationships, right? Those are.
But it's true, and that's part of the work that ILRU does, is to help change this narrative within the Canadian framework. But also, Indigenous law can also help inform a lot of the way that common law and civil law works, in the sense that also restorative justice is something that can be highly informed by Indigenous practices. And so I sit now on the Victoria Restorative Justice Board, and that's sort of my way of keeping my foot in the legal traditions. But the traditional legal systems are very much adversarial, in the sense that there's someone who's wrong, there's someone who's right, and it's not necessarily about equity or justice. And when you're looking at restorative justice through an Indigenous lens, it's often about finding equitable solutions and community healing and trauma healing. And maybe can you talk about that component a little bit and how that can inform mainstream law?
Sure. I think one of the reports that you may have had an opportunity to look at is the Cree Legal Traditions Report. And I don't know if you've also had a chance to look at some of Hadley Friedland's writing.
Sure, I will imagine that most of these people have
not. Fair enough.
Yeah.
Hadley Friedland wrote a wonderful book called it's like Cree Law and the Wetago.
Yeah.
And the Wetago, what she argues, is a Cree construct which enables people to deal with those of us who become harmful to one another. And the ways of doing that are, she sets out the principles that surround and govern treatment and relationships, sets out accountability, substantive and procedural rights, obligations, like all of the different ways that we can structure our relationships so that they're healthy with one another, and so that there are times when people become dangerous, that there's sanctions and other when the community is in danger and so on, or children are vulnerable. There are sanctions, but there are also procedures that you have to go through to ensure that they're not abused. Part of what's so interesting to me in looking at the oral histories, whether it's Cree or Dene or so on, is that many of them are about abuse of power, about leveling the playing field and accountability for those that have power, whoever it is, whether it's a medicine person or a healer or anything else. And so those processes are available today and can be drawn on today. The other thing which is really important about her work and the work that we're doing is that it isn't about a big boss having all the control, but rather who are the authoritative decision makers. And historically, those were could be medicine people. There will be 3 or 4 groups of authoritative decision maker in any society. So depending on the kind of legal problem, that determines how the legal problem is approached by the authoritative decision makers, but it also determines who they are in that society. So it's a way of broadening responsibility for one another and sharing that and supporting each other through that process. That work also requires the rebuilding so that we have healthier relationships than what we see in many of our communities now.
Yeah, there's so much trauma and so much healing that needs to be done across the board for many, many peoples in this country. I think that's probably one of the truths about being born on this planet, is that you are going to be traumatized and we all are going to have to work to heal our trauma. But there is an incredible legacy of trauma within Indigenous communities through colonization, through the residential school program, through missing and murdered Indigenous women. And these are conversations that are difficult to have, but need to be had in order to change the reality right now. And both of you are fierce advocates in terms of, well, let's say across the board. I would say you guys really are advocates across the board in general, but also specifically in terms of feminism and gender relations and challenging the patriarchy. And it's well known, you've both been published on these sorts of topics, you do a lot of work in these sorts of topics. What is it like to go into a community that might not have the same respect or understanding of gender equality? And how do you work with communities to change that conversation?
You have to start where people are at.
Yeah. I would say that in addition to a long history of, and you know this, of trauma, there's a long history of resilience, right?
Yes.
That's what we identify when we're talking with people in community. The conversations around women and gender and gender equality more generally occur. It comes. It may not come in a formal focus group. It may not come in a public meeting, but through engagement, we hear of what's happening in community, and we're often hearing of women that are doing their work within the community to push back against whatever abuse of power they're experiencing. And what we try to do is carve out space to enable those discussions to come in and come into the reports where necessary. What we find in the work that we're doing is that when communities want to do our work, our work is all project-based funding. So we go out, we seek funds. We have some funders that provide a bit more stability. But when communities come to us with their big issues that they want to engage with, they are typically around high-level governance or lands and resources, environmental questions. So like we see within settler society, like we see in all societies, the question of gender equality or any injustice experienced by people who experience conditions of marginality or vulnerability are often pushed to the side. They're not prioritized. So what we do when we have a little bit of extra money and can take up the work that we do at our own initiative is we try to pinpoint where are those spaces of lawlessness that need some investigation that maybe won't come up through the organization as being a priority, not because it's not recognized as an issue, but because it's not the immediate priority to the people that are engaging with us. And we spend our time working on those issues at our own initiative. So that's the one place where we wouldn't necessarily have a community come to us and say, we want to work on human rights law involving women, although we do have projects like, we do have one like that. But we sought the funding for that. Yeah. It didn't come from the community. We sought the funding to enable that to happen. So that's how we negotiate needing to create these spaces for conversation about the harder questions that arise within all societies, but specifically in our work, Indigenous communities.
Yeah, I really appreciate that, and I just want to extend my gratitude, especially in the inclusion of LGBTQ plus perspectives, two-spirited peoples, which is not often a conversation in mainstream anything or within Indigenous societies. So to have that be part of the conversation means a lot to me, and I think to a lot of other people too. So thank you both for that. When we're talking about one of probably the most sad and horrific truths about Canada, which is missing and murdered Indigenous women, there are a lot of discussions we could have about it. But I think maybe we should start in terms of the legal perspective, which was the Truth and Reconciliation Committee. I think there were 94 findings. There hasn't been any sort of real prosecution or justice necessarily brought out of that, but you are doing some work in conjunction with some of your research projects. Maybe can you talk about those a little bit and what you hope to see change and happen in terms of protection of Indigenous women?
Yeah, so there was also the Missing and Murdered Indigenous Women and Girls inquiry, and there was another inquiry in Quebec. And so Hadley and I were actually expert witnesses for both of those. My frustration with the National Missing and Murdered Indigenous Women and Girls inquiry is that while it was really important and has created resources. It still locates the problem of violence against women and girls and others who are vulnerable for all kinds of reasons, including LGBTQ folks. It still locates the problem of violence outside of the Indigenous communities. And part of the work that we're trying to do with the human rights projects that we have is to look for internal, from an Indigenous law perspective, legal understandings of dignity and fairness, inclusion, safety, all of those kinds of things. So not assuming that they only exist outside of Indigenous communities, that they come from the UN Declaration on Indigenous Peoples, or they come from a human rights legislation, or they come from the state with the charter or whatever. Every system of law includes how people relate to one another, like what the legal personalities within that society are, how they're created, and what kinds of relationships are supported in that society, so that one can imagine rights within those relationships. So the frustration I have with the work thus far is there's not enough focus, not any focus for the most part, on Indigenous law, and where it locates the problem as being outside, external only to Indigenous. And there is external violence against Indigenous women and girls, I know that, but we also have violence against each other where our communities aren't safe for women and girls and anybody else that's vulnerable according to what people are doing. So, we've made different proposals for how to create justice shelters for women and girls. We haven't been successful.
It's a hard topic, but it's a starting point with the work that you're doing. Jess, do you have anything else to add on terms of the work that you guys are doing?
I think Val said that quite eloquently. Yeah, there's a lot of work to do in so many places. Something that I often have to remind myself of is just the time and the place that we're in now. We're confined to what we can do in this time and place, and that the work of any sort of justice or reconciliation or truth gathering is an intergenerational project. And we do the best that we can in the moments that we have. That helps me from the panic of feeling like I need to accomplish much more than I can feasibly do and logically do in my lifetime.
So in a paper that I wrote called Indigenous Women Talking, I imagine 30 years from now, two of my grandsons at the law school having a conversation. And behind them on the wall is a sign that said, Indigenous Feminisms is Medicine for Indigenous Law.
It's beautiful, and it's also available online. If you have the opportunity to Google it, I would highly recommend that you watch some of Val's storytelling in general. There's some really interesting stories out there that are worth viewing. And it's such a big topic, and I don't want to just move off of it carelessly, but just to say again, thank you for the work that you're doing, because it's important work, and there needs to be a lot more, and having traditional white colonial men be behind the sort of law and justice of it feels wrong, and I think it's important to have female perspectives, and especially Indigenous female perspectives, in trying to address safety for people across the board. But you did mention the United Nations Declarations on the Right of Indigenous People. Originally, I think it was in 2007, Canada was one of 4 signatories to vote against the inclusion. Finally, I think it was 2016, Canada adopted the resolution, and recently British Columbia is the first province to adopt the resolution. How will this affect the Canadian landscape?
Again, I think,
and some kids playing next door, so that's just what you get in this interview. Sorry guys, but it's what you get. But you get a beautiful background.
It's life. This is not uncommon in our work.
I think like so many things, the mere fact of the conversations is a starting place. So, and what I don't want to say is that either the declaration or the BC provincial legislation are merely aspirational. They're more than that. They actually provide ways to think about Indigenous law, and ways to think about who people are, and ways to think about practical changes that can go on in the structuring of those relationships. I guess, like there's so much going on right now and all the time with Indigenous peoples, in terms of fisheries, in terms of water, in terms of land, in terms of governance, in terms of a gazillion other things that communities are engaged with. And there are possibilities that every one of those will be informed positively by new ways of understanding the relationships through what's available. It's not going to happen overnight. Unfortunately, what happens is that it's like the state has an elastic band around it, and every time there's something new that comes up with Indigenous peoples, they revert to their starting position, which is that there are no Indigenous rights, blah, blah, blah. And then you have to work to get them up to speed. And so it's very frustrating that that ends up being the default for the state. We have a friend who's working on a paper. Her name is Jana, and one of the things that she's arguing is those things that the state should know better.
They should.
And just pointing out, like, here's
10 things
all
the state should have learned in kindergarten.
Yeah, or learn through Delgamuukw,
Yeah,
or learn through
no, I know.
Calder, or learn
Absolutely.
through any number of other reconciliation processes, or inquiries, or litigation, and on and on and on and on. It's like Indigenous peoples have spent lifetimes, generations, educating Canada. The state should know better and shouldn't be making some of the arguments it's making, but they still do that. So there's still frustration, but pessimism is the worst form of arrogance, and I would much prefer to be positive about our potential, all of our potential.
Yeah, I'll take that as well. I would like us to be positive about it. I also have reservations in terms of the meaning of the implementation, but I will hope for the best also, I think, on that topic. We're neighbored to this massive country below us called the United States, where there is basically a racist president at this point. I think that's a fair statement. And who's instigating violence against his own people, but specifically against minorities, vulnerable people, people of color, Indigenous people, Native Americans. And we like to think in Canada that we are somehow not part of this conversation, but that's not the reality. The reality is Canada has a long history of oppression, suppression, and its own relationship with minorities, people of color, Indigenous people, Black Canadians. Why do you think the movement has gained as much prominence as it has now? And why is there such almost a sense of backlash from people who might be racist, or who feel more emboldened to speak their racist truth?
I think there's a few reasons. I think that social media has enabled the public profiling of violence, specific incidents of violence against Indigenous peoples, to be brought to the public gaze in a way that it can't be denied or put down, or what would usually happen is that the Indigenous person who's beat up is blamed for that violence. So I think part of it is the social media and the new tools that are brought. I also think another one of the dynamics is the shameless racism from south of the border has been a part of that emboldening of those that are racist. It's like, so if the president can say these horrible things, and what the heck, we can all say it. I think that because we live in, we're in a global Canada is global, whether we like to recognize that or not. So I think that there's numbers of factors that have contributed to the particular mix that we have now. I think that the success of the Idle No More movement in terms of getting groundswell, everyday person actively politically involved, I think that the Wet'suwet'en were phenomenal in getting public support right across Canada in a way that has not been, we haven't seen before in Canada. I think that those efforts where people can see each other taking up a position and talking about what matters to them, we need to be able to see each other doing that. And that's part of what people have been able to see. And that has brought the energy around to oppose the violence that is also a part of our country. So I think that there are many factors here. I think that the biggest thing is that we're living in an anti-intellectual time where there's a want to have easy answers. There's a want to say the market will solve it. If government will just get out of the way, we don't have to do anything. We don't have to change anything. Let the market take care of it. Like there's a want for those kinds of easy ways out of complex situations. And the consequence of that is a refusal to look around at the world and try and understand it, even though it's hard and it's complicated. Like somebody wrote a book about 20 years ago, or maybe not that long ago, about when did America stop thinking? I don't think it's just America. I think that this is a larger phenomena. I've been to meetings in South Africa on this very issue. There's lots of contributing factors to it. The idea is that there's so much blood and guts in our world. That's what we have to focus on. We can't focus on ideas or big issues. We have to take care of the nitty-gritty or the practice or whatever people are calling it. There's lots of ways of turning away from the fact that we need to think, and we need to think together to solve problems.
Yeah. I've spent some time thinking about this. My parents are both Americans, and my father's side is Jewish. So I think that there is a magnification of what's happening now, but I know within my own lived history that what's happening south of the border is not an anomaly. It's just part of its history. I think what's interesting now are the things about our statues being taken down, or the dismantling of the symbolism of these racist monuments, and the racism, the embedded racism in that country. And we see that a little bit here today in Canada, but it's just starting. And I think a lot about the response to and the fear response to what happens when my heroes are taken down, what happens when the symbolic, the illusion of America being land of the free, home of the brave, is completely dismantled before your eyes. And on top of the anti-intellectualism, just a commitment to narrative, a commitment to the propaganda that people have been fed their entire lives, like the propaganda that we're fed our entire lives about Canada being the peacekeeping nation. As though we weren't fourth in the arms race, right? These pieces are always there. I grew up, as I said, in Treaty 6 territory, where I remember as a kid there being cross burnings. I remember there being a neo-Nazi resurgence in Edmonton at the end of the 80s and the early 90s. So what allows it to escalate is probably, yes, having an absolute, unabashed white supremacist in the Oval Office to allow the fire to launch, to give people permission to do it, and the instinct of people to say, well, even in the face of that, there's enough of us to push back, to say, no, things still have to be dismantled. We still have to have this conversation. That gives me sadness, and it also gives me a little bit of hope. Because again, pessimism. Don't want to be on the side of pessimism. These are histories of resilience, and perhaps we can reform in this madness.
Yeah, I agree, and I think crisis brings out the best and the worst of society. That we've seen beautiful moments of people caring for each other and helping each other and wearing masks and caring for elders in society, and we've seen horrible acts of racism against Asian people, against Indigenous people, against Black people. I think it's brought light to the defund the police movement, the way that we deal with mental health services.
The refund society movement.
Refund the society movement.
Yeah.
Better allocation of resources within society movement. And it's an ongoing conversation. I have a personal perspective that I think that Indigenous people are more aptly able to challenge the status quo than others in society, as land defenders, as water defenders, and that is a threat to powers that be. If you are a neo-liberal capitalist, if you are a white supremacist, and you want to maintain your own power, authority, and legitimacy, one of the biggest threats to you is land defenders and people with land knowledge and who could help change the conversation. And so sometimes I feel like some of the people in power do this lip service of we're all inclusive, but behind the scenes they're working very hard to keep people suppressed because it challenges their own power and authority. And what you guys, what you people, what you folks are able to do is really challenge the status quo and the powers that be within the legal framework in a way that really I haven't seen done before in Canada. And that's why it was so important for me to have this conversation with you, because I do think that you are changing the landscape of Indigenous law across Canada and the greater landscape of law across Canada. And I would keep talking to you for hours and hours and hours about all of these things, but for people watching, this is just an introduction into the work that you do, into some of the topics that are important right now. And I just thank both of you so much for your time and all of the work that you're doing. So,
Thank you.
Val Napoleon, Jessica Asch, the Indigenous Law Research Unit in Victoria, British Columbia through the University of Victoria. You can find more information about them online, and all of the links will be provided in the description below. Thank you.